All right. At this time, based on what I've heard, Mr. Walterman, I can't find that you're capable of representing yourselves in this case. In fact, I think an evaluation might be in order. Because I'm not sure you understand what's going on here.
I certainly understand what's going on.
Well, based on my readings of what you've written in your pleadings and your answers to my questions today and your allegations of gang stalking and corruption against you, but you've given no reason why that would happen or even really who's doing it, I've got concerns as to whether or not you can really handle this case on your own, number one, and whether or not you're even capable of entering a plea or going to trial.
Your Honor, this is Jason Walterman, 24 CF 1518. You asked to put him on towards the end of today's
Yeah, I
docket.
just didn't want to do the Ferretta hearing because it takes a while and leave everyone else waiting.
Yes, Your Honor.
All right, Mr. Walterman, what are you asking the court to do?
Dismiss these charges.
Well, that's not what we're here for. No, that's not going to happen. I don't get to dismiss charges unless a motion is filed.
Yes, I filed a motion to suppress and a motion to dismiss. I guess it's not reached again, the mail for the jail.
Y'all seen anything?
This will be the second time I've submitted it.
Well,
Right.
the issue is, Mr. Walterman, is that you're represented by counsel. And so
Yes.
when you file things, when you're represented by counsel, unless they're adopted by your lawyer as motions they want to pursue, then they're a nullity. It's like they never happened. They get struck. So other than dismissing the case, what are you asking for?
You reviewed discovery, see it's been amended several times due to the unlawful traffic stop. Everything that's supposed or alleged evidence is inadmissible in court. The charges are completely fraudulent. I did not possess a gallon of methamphetamines nor a gram of fentanyl at all. It was a targeted,
Mr. Walterman,
yes, sir.
earlier you said you wanted to talk to me about either representing yourself or getting a different lawyer. So that's what I brought you back to talk about.
Yes, sir. Yes, I asked counsel to put these motions in with the case law, and I did all the work and told her about it. She didn't submit it, so here I am. I guess I need to represent myself. I don't want to be another statistic.
Raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
So help me God.
All right. Can you state your full name and date of birth?
Jason Michael Walterman, 79, 45 years old.
And so, Mr. Walterman, do you understand that lawyers have an ethical obligation not to pursue motions that they don't think that they can't in good faith think they're going to win? You understand that?
I realize that it's working against me, that's for sure.
That's not what my question was. My question is, do you understand if you ask your attorney to file a motion that he or she says, I don't think I've got a good faith basis to file, they're not going to file one because it would be unethical for them to do so?
I guess that's why we're here today,
Okay.
needing to relieve my
But
counsel.
again, my question is, do you understand that?
Do I understand that it's, that she didn't want to put the motion in for me?
I asked you a question. I asked if you understood it. That usually involves a yes or no answer.
Yes.
Okay, so you do understand that. So you've asked to file, or you've actually filed your own motions, but since you're represented, they're a nullity. Okay?
I must submit those?
Unless you're representing yourself. But I have to go through what's called a Ferretta inquiry to find out if I think you're able to represent yourself. So, again, what are you asking for today?
I would like to represent myself. Do not
Why?
believe that the council has my best interest at heart, or
All right, so the issue, do you want to represent yourself, or you just have an issue with your current counsel?
You know, I realize the state's attorney's office is running the whole program between the sheriff's department, the public defender's office, even the outreach or conflict counsel. And, you know, as much corruption as I've seen them operating at, I don't feel safe with any of them handling my life. Manufacturing charges, tampering with evidence, falsifying police reports and certified documentation, targeting individuals, me especially, defamating my character publicly, personally.
Why do you think you're being targeted?
That I have not figured out yet.
So, you may not know exactly who is targeting you or why, but the answer is actually pretty simple. The person watching you is the police, and the reason they're interested is because you were allegedly trying to sell a large amount of drugs. In other words, this isn't some mysterious setup, it's the police doing exactly what they're supposed to do, stopping illegal activity.
I'm stuck with no resources, you know. Have any law library, real.
Yeah, but you understand that you're currently in jail because you failed to appear for your
Yes, sir.
trial date.
I sure did.
All right, so are you trying to represent yourself?
Yes, sir.
That's what you want. Okay. How far have you gone in school, Mr. Walterman?
Almost the 12th grade.
If I asked to verify information, I'm not trying to be offensive or anything like that, Mr. Walterman, but what you said was you didn't finish high school.
No, sir.
Did you get your GED?
No, sir.
And do you have a career field?
Professional construction worker, supervisor, superintendent.
Okay. And when's the last time that you've worked?
6 months ago, something like that. I've been in jail for about 5 months now.
Okay.
This has cost me 2 jobs already. My vehicle, my place to stay twice.
I'd appreciate if you would just stay on track with what I'm asking you, Mr. Walterman.
Yes, sir.
Have you ever represented yourself before?
No, sir. Not in a court of law.
Okay. Even in a traffic ticket or anything like that?
I don't believe I've been to no traffic court.
Okay. Do you understand that you have a right to a lawyer?
Yes, sir.
And you understand that one has been appointed to you already?
Yes, sir.
But due to your concerns about what you said with the corruption, you'd like to represent yourself, is that right?
Yes, sir.
Even though the state of Florida pays for the lawyer for you?
Yes, sir.
Okay. And do you understand the advantages of having a lawyer?
No, sir.
Okay. So, say again?
I said, no, sir. I haven't received any advantages.
Okay. So a lawyer's legal knowledge and experience may favorably affect things like bail and pretrial release possibilities, may result in obtaining information about the case through skillful use of discovery devices, may uncover potential violations of constitutional rights, and take effective measures to address them, may ensure compliance with speedy trial and statute of limitations provisions, and may identify and secure favorable evidence to be introduced later at trial on your behalf. Do you understand all those things?
Yes, sir.
Okay, but you don't want to have a lawyer do that for you.
Constitutional civil rights have been violated to a serious degree already. I think I got my best interest at heart. If I had the law resources, I could skillfully and professionally present the actual facts of the case, and that should be enough to abolish my charges and set me free.
First off, you've got to give him a perfect 10 out of 10 for confidence, even if that confidence is seriously misplaced. And while believing you have your own best interests at heart is one thing, trying to defend yourself against a felony is a completely different story. Sometimes, having good intentions doesn't mean you're making the right decision, and representing yourself in a serious criminal case is definitely one of those moments.
What do you know about the Florida Evidence Code?
What I know about the Florida Evidence Code,
Yes, sir.
I can't say that I know anything about it.
Okay.
I haven't had access to any of my evidence except for the discovery. And then the times that I discussed my discovery with my counsel, the discovery got re-amended again and again.
Okay, but how do you think it's been amended?
It says so right in the
I understand, but what changed?
the amount of people that was at the stop to begin with.
Why do you know? How do you know how many people were at the stop?
I was present.
Okay. So, because I'm reading in your motion that you filed to suppress evidence that you said there was 12 to 15 law enforcement officers on scene within 6 seconds of them pulling you over.
Yes, sir.
So
We were
what's the,
sitting still in a parking lot when they come into the parking lot with no lights.
I'm not asking you about the facts of your case, sir.
Yes,
I'm
sir.
just trying to make sure I understand your issues with discovery.
Yes.
If you know that there was 12 to 15 law enforcement officers there, what's the issue with them amending to make sure all of them are listed in discovery?
Well, they didn't present the evidence until I said something about it. There was just one account or two accounts of an officer on the scene where it took me saying something for them to add some more officers on there, which still there's only one account of video footage. When there's that many officers on the scene, there should be that many video accounts plus their vehicles. You know, they exist and they were there. That's part of the evidence that's not being presented. Also, the arrest report has Jason Walterman. My name is Jason Walterman, spelled wrong. My description is wrong as well. And there's many discrepancies and false statements in that arrest report.
Mr. Sheik, do you know how many discovery exhibits the state has filed?
I believe there are the original discovery and then two amended, Your Honor. One was just adding more of the officers that were present on the scene, and then the other one was the FDLE report, Your Honor.
So basically, the state has just revealed that a Florida Department of Law Enforcement officer is involved, meaning someone from the crime lab can testify about how the substances you were caught with were identified as illegal drugs. At this point, the court keeps offering you a free lawyer for a reason. This might be the perfect time to actually take that advice.
So, Mr. Walterman, I'm looking at the discovery exhibits because you said they've added a bunch of officers.
No,
Hold on. From my reading of it, the only one they added on the amended discovery exhibit was a Deputy Langer. Everyone else was already listed, and if you read on the actual exhibit, it says, this amended discovery adds previously unlisted Deputy Sheriff Langer and recategorizes the deputy sheriffs who were previously disclosed in initial discovery dated 8/6/24. So it only added one person. It just recategorized people as they need to be under Florida Rule of Procedure 3.220. The second amended discovery added an FDLE chemist, who I'm assuming tested the substances to determine what they were. So there's only one new law enforcement officer that was added, and you made it sound like there was 12 to 15.
I'm asking where's their accounts of being on that scene? When it only shows those few officers where there was a whole lot more. Like I said, but before I could put the gear shifter in park, there was a splash of a targeted, coordinated event, not an everyday ordinary traffic stop as my counsel told me it was. My tag light was not out of place, nor was the tag. It was right on the bumper.
I'm not asking you anything about the facts of the case, sir. Mr. Walterman, have you ever seen a criminal trial? Have you ever seen jury selection?
No, sir.
You think it might be an advantage to have a lawyer who's participated in trials and jury selection to aid you through this process?
I couldn't afford an attorney that was in my interest.
You understand that at a trial you have the right to remain silent?
Yes, sir.
And do you understand at a trial you have a right to testify and tell your side of it?
Yes, sir.
Do you think it might be an advantage to have a lawyer to counsel you on as to which one would be better for you and give you the pros and cons of those things?
Yes, sir.
Okay.
Had a lawyer, but I didn't receive any sureties or counsel of upholding nature.
I'm not sure what you're saying. You're going to just be a little louder, Mr.
I
Walter.
wasn't presented with any factual knowledge or, how to guide this case with counsel, other than she wanted me to commit perjury and be extorted for $1,000 to accept 2 felony drug charges that I didn't possess any drugs for to begin with.
She wanted you to commit perjury and be extorted.
Well, that's what admitting to guilt would have been committing a crime to say I'm guilty. That is perjury, isn't it?
Well, technically it could be perjury, but it sounds like you may have misunderstood what actually happened. Your attorney likely passed along the prosecution's offer and explained that, in her professional opinion, accepting the deal was probably the better option. But the key point is that she can advise you. She can't make the decision for you. Ultimately, the choice to accept or reject the offer was yours.
Well, Mr. Walterman, most people who enter a plea in my courtroom end up pleading no contest, which means they're not admitting their guilt, and they're doing so because it's in their best interest. Not admitting their guilt at all.
But I am not guilty.
I understand. I'm just... Do you understand that a lawyer can call witnesses for you and make sure they come to court? I need an answer, Mr.
Yes,
Walter.
sir.
Okay. The microphone doesn't pick up nodding.
Yes, sir.
Do you feel that you could question witnesses who appear against you?
Yes, sir.
Okay. Have you ever cross-examined a witness before?
No, sir.
So based on my earlier questions about knowing the evidence code, wouldn't it be helpful to have someone who is familiar with the evidence code question the witnesses?
Would most certainly be helpful.
Okay. But you don't want that advantage?
Yes, just counsel would be just fine with me. I was stating I haven't received that.
Okay. But again, I've asked you if you had an issue with your lawyer, and you said you just want to represent yourself.
Well, my best interest wasn't being looked out for. That's why I was needing to.
How so?
I did the work, studied the case law that backed up the findings for my plea of not guilty for every account with extra backup on it. Gave her the motions or told her
Case
which
law
motion.
for your plea of not guilty?
Well, that was backing up the case that I'm fighting right now for my freedom, and the charges that was put against me, stating what made those charges not of any merit or substance, and I wasn't getting nothing but this is the best I can do, plead guilty to something you're not guilty of. Okay, to target individuals in Florida to do this type of extortion or bullying or gang stalking.
Who's gang stalking? What does that mean?
It's where a group of individuals conjure or coordinate coincidence to attack a being, to take advantage of it.
You're saying someone's doing that to you?
I love how he looks around the courtroom like everyone else must be in on some massive plan to keep him from walking free. Meanwhile, there's an entire courtroom full of people watching this unfold, and the judge is now ready to make the important decision on whether he should be allowed to represent himself.
All right. At this time, based on what I've heard, Mr. Walterman, I can't find that you're capable of representing yourselves in this case. In fact, I think an evaluation might be in order. 'Cause I'm not sure you understand what's going on here.
I certainly understand what's going on.
Well, based on my readings of what you've written in your pleadings and your answers to my questions today and your allegations of gang stalking and corruption against you, but you've given no reason why that would happen or even really who's doing it, I've got concerns as to whether or not you can really handle this case on your own, number one, and whether or not you're even capable of entering a plea or going to trial.
So can you appoint me some just counsel? So, that's going to be
I
fair within the law.
have. You haven't told me anything that's wrong with your counsel. Other than just to say this kind of conclusory statement that they're unjust.
I'm not guilty of the charges, yet I was asked to plead guilty to 2 felony drug counts that I didn't
Were you
possess.
asked to plead plead guilty, or were you told what your plea offer was?
Just that was the best that she could do.
Okay, and sometimes the best that can be done
Break
is
the
not.
law and pay them $1,000 to just walk away.
Again, I just don't really think you understand how this process works, and your lawyer's trying to explain that to you. And at this point, I'm finding under a FREDA inquiry that you're not capable of representing yourself.
Okay.
Ms. Rivers?
Your Honor, the issue remains that he refuses to get the evaluation. I've tried twice for the evaluation. He refuses to get the evaluation.
Is that the one you've tried to do internally?
Yes, Your Honor.
All right, then I'd like an order appointing
Yes, Your Honor.
a doctor to do that evaluation. And Mr. Walterman, I'm going to order you to take that evaluation. And if you refuse to do so, you'll be held until you agree to do it. Because it's concerning that you're refusing to follow your attorney's advice in doing this. And now, from what I've heard, I've got the same concerns that you may not be competent to proceed. Anything else, Mr. Walterman?
Sir?
All right. I'm going to put it on October 29th at 9. I would like that order so I can sign it certainly this week, Ms. Rivers, and then they'll send someone out to talk to you at the jail.
All right.
It may be done by Zoom.
What about new counsel?
Again, you haven't told me anything other than a conclusory statement that she's unjust. So I'm not going to remove her from your case and add someone else until you show me that she's done something wrong.
Kind of hard to show you any evidence. I'm stuck at the county jail. I talked to her. They come and stole all my paperwork, destroyed all the stuff, my property, immediately after I talked to her the first time. And I finally got a rediscovery, and it showed that it's been re-amended after I spoke with her again and was telling her some of the facts of the case that would be presenting my innocence.
Discovery is amended all the time, Mr. Walterman.
Yes, that's right.
As they add an officer who they didn't initially know about, or adding someone who's new as far as an analyst who's looked at substances, or like the chemist that was added in your case. Those people weren't witnesses until they became witnesses during the case, into the course of the case. I can tell you, as I was a prosecutor and a defense lawyer before I took the bench. I've had cases where we've had 15 to 20 amended discovery exhibits, depending on what the case is. It's just part of the process.
What about a fair and just due process? We were supposed to go to a trial a long time ago, and they keep putting it off.
You've missed court twice and have failed to appear twice. That's why you haven't had a speedy trial. And you didn't appear for your docket day. And because of that, I issued a warrant for your arrest because you didn't show up. And that's why you're sitting in jail, because you're a flight risk at this point after 2 times missing court and have to be rearrested. Anything else, Mr. Walterman?
No, sir.
All right, thank you. October 29th, 9 o'clock.
Honestly, this is probably what's best for him, but I can't remember the last time I saw someone insist on representing himself only to end up facing a mandatory competency hearing. And just when you think things can't get more interesting, we're heading to Kansas, where another young man seems to believe probation rules and court orders don't apply to him, until the judge makes it clear that ignoring them has serious consequences.
All right, we'll go on the record in State of Kansas versus Brady Smith, case number 24 CR 101. Would counsel announce appearances, please?
May it please the court, the state appears by Joe Gillette, County Attorney.
William McClendon for the defendant, Brady Smith, who appears via Zoom from a separate location.
And also appearing is Ed Ketley with Community Corrections, who is Mr. Smith's ISO. We're scheduled today for hearing on a warrant to show cause announcements. Mr. McClendon.
Yes, Judge, we'd be stipulating to a probation violation
All right,
on this.
Mr. Smith, you wish to waive evidentiary hearing and stipulate to the violations?
Yes, Your Honor.
Do you understand that you are entitled to have a hearing? At that hearing, the state would be required to prove by a preponderance of the evidence that you did in fact violate your probation as alleged in the warrant to show cause?
Yes, Your Honor.
You understand that by waiving your right to hearing and stipulating to the violations that the court will find that you violated your probation?
Yes, Your Honor.
And do you understand that you could be looking at serving some sort of a jail sanction, that your probation could be extended, or in some situations, your probation could be revoked and you could be ordered to serve the balance of your sentence?
Yes, Your Honor.
All right, I will find, Mr. Smith, that you've made a knowing involuntary waiver of hearing and have stipulated to the violations as alleged in the warrant to show cause. Based on the stipulation, the court will find that you've violated your probation. Is there any sort of an agreed upon disposition, counsel?
Judge,
Yes, Judge. Go ahead. Sorry.
I'm recommending, this is his first revocation, and it is a Senate Bill 123 case. I don't know, and Mr. Ketley will have to tell us if Cali County will even try to take him back. But he needs to have a sanction. I'm going to ask for a 3-day quick dip. And then he will need to meet with Mr. Ketley as soon as he is released. He was supposed to be at the courthouse today so that he could start his quick dip today. So he's going to have to get himself turned in on his quick dip. I'd like that to be a condition of probation and of his community corrections. If he does not get himself turned in for his quick dip, then I would like authorization for Mr. Ketley to issue a warrant.
Mr. McClendon, your recommendations?
Judge, that'd be our recommendations as well. We just ask that he have till 5 p.m. tomorrow to turn himself in.
Mr. Ketley, any information you wish to provide?
No, Your Honor.
So he's being supervised in Cali County?
No, Your Honor. They tried to contact him. He never responded to them. So he's been kind of in limbo ever since.
All right, and he hasn't been reporting to you?
That's correct.
Okay, and he hasn't started Senate bill treatment?
I believe that's correct.
So, not only did he fail to complete the treatment he agreed to as part of his probation instead of going to prison, but he also stopped reporting to his probation officer. Unfortunately for him, that's not how probation works, and the judge is about to make that very clear.
All right, Mr. Smith, anything you'd like to say?
No, Your Honor.
How come you're not reporting?
My driver, so my wife has been having problems with her left eye, and she went into the eye doctor yesterday, and they did some sort of pressure test, and most people have 0% pressure on their eyes.
I don't need to know all the details. So since January, you haven't been able to report or call in?
Well, I talked to Ed initially after we got sentenced and whatnot, and then we were waiting for Cali County to get a hold of the paperwork and all that, and then
Did you
like I was
contact
telling,
Cali County to find out what the status of the paperwork was?
well, so I got into a rollover accident and I was in the hospital for a month, and that's when Cali County had called me, and when I got out, they had already issued a warrant.
How come you haven't started treatment?
I'm currently waiting on a bed date right now.
What, for where?
Huh?
Where?
At PFH.
Where's that?
It's in Winfield.
Where are you physically located right now?
I'm on the side of the highway, 40 minutes away from Eureka.
All right, you need to check in by 12:30 today and serve 3 days in jail.
I don't have, that's my problem right now, Your Honor, is I don't have like any way to move at the moment. I don't have a driver's license and my wife can't see at the moment. And so I've been trying to find a ride since like 8:30 this morning.
So you and your wife are sitting in a car on the side of the road and she's unable to drive?
Yeah, like I was saying, her vision in her left eye has been completely gone. So she's sitting right here next to me. I mean, she went to the eye doctor yesterday and they're trying to get it figured out. And it was like just blurry and it would kind of come back, you know, but she said that she can't see
Have
anything
you
out
made
of her left
contact with
eye.
anybody to come get you?
That my mom is the only one and she's just under 2 hours away from me. And I'm still waiting for her to tell me if she can come or not. Other than that, I don't really have anybody to come get me. Because like her mom and sister and everybody are all at work until 5 p.m. And like I said, I'm just waiting on my mom at the moment to see if she can even come get us.
He better hope his mom can help him get there on time, because missing that check-in could cost him the deal entirely. And now, the judge is ready to lay down the consequences while giving him some advice he seriously needs to hear.
You need to report to the Greenwood County Jail by 5 o'clock today.
Did you say can I or I?
No, I said you've been ordered to report there by 5 o'clock p.m. today.
Okay.
If you need to start walking, start walking.
Alrighty.
You need to start taking your probation seriously. You're lucky you're only getting 3 days.
I know, Your Honor.
So you're to report by 5 o'clock p.m. today to the Greenwood County Jail in Eureka to serve 3 days as a sanction. Then you'll need to be back reporting. Mr. Catley, have you provided him with reporting instructions or do you need to do that?
I have not yet, Your Honor. I haven't spoken with him.
Does
Brady,
he-
you just need to call me on Monday when you get out of jail and we'll set up something.
Okay.
If
I'll get
you're
out on
not-
Sunday,
you're
and so
not-
just call you first thing Monday
Mr.
morning.
Smith, I'm trying to talk.
That's my fault. Call me Monday. That's correct.
If you don't report by 5 o'clock p.m. to the Greenwood County Jail, I'm going to order that you be held until we can get you back in front of the court.
Okay, Your Honor.
Understood? So if you can't get a ride, you need to start walking.
Okay.
It's a nice day. Are you working?
No, not at the moment.
Okay, why aren't you working?
Because I've had a lot of trouble trying to get a job because everybody that I try and get a job for, they'll pull my criminal history and they're like, eh.
Well,
Like,
I know
I've
plenty of
had
people.
interviews at Spirit. I've had interviews at Creekstone. I've had interviews at like 2 or 3 more places, and every time go in for it and whatnot, and then because
All
of my
right, I don't
criminal
want to hear any more excuses.
Judge, I also need to have a determination as to whether or not there is any bids, application, or attorney's fees.
I know, Ms. Gillette, that's why I'm inquiring about his employment. I'm going to order that you pay $250 towards Mr. McClendon's attorney's fees for today's hearing.
history. Okay, Your Honor.
What's your controlling sentence in this case?
20.
20 All right, I hope this is a wake-up call for you, Mr. Smith, because you've got 20 months in prison hanging over your head. If you don't start taking probation seriously, I'm just going to put you in prison.
Okay, Your Honor, I understand.
And by not checking in by 5 p.m. today would be one of the first steps towards a 20-month stay.
Okay, Your Honor.
All right, Ms. Gillette, anything else we need to do today with Mr. Smith's case?
Nope, I think that's all I needed from you. Thank you.
And Mr. McClendon?
No, Your Honor.
All right, Mr. Smith, make sure you call Mr. Ketley when you get out of jail, assuming you get checked in and serve your 3-day dip.
Okay, I can do that, Your Honor.
All right, if there's nothing further, we'll be in recess. Have a good day.